For 8 years, the analyst responsible for testing drug evidence in a Massachusetts state laboratory was high on the drugs she was supposed to be analyzing. Sonja Farak worked at the Amherst Drug Laboratory, a state-certified satellite facility whose findings were entered into court records and relied upon to convict defendants across western Massachusetts. She began taking substances from evidence bags in 2004 and used methamphetamine, crack cocaine, LSD, and ketamine, not in private, but in the building where exhibits were processed, logged, and certified. Her laboratory reports were produced, signed, and sent to prosecutors. Her testimony was given under oath. The official chain of custody remained intact on paper, even as the physical evidence passed through her body. By the time of her arrest in January 2013, prosecutors estimated that approximately 35,000 criminal cases had been handled by Farak. The Attorney General's office learned within weeks that contamination and tampering reached far beyond what was being publicly acknowledged. For 2 years, they suppressed the full picture to preserve convictions. The Amherst lab was small, staffed by a few analysts who supported local police departments and prosecutors. Farak carried the credentials and the state certification that lend a veneer of objectivity to forensic conclusions. That credentialing created a structural trust. When a chemist signs a report, the system assumes the data are untouched and the analyst unimpaired. Farak abused that trust. She started with small pilferings, learning which samples could be accessed without causing inventory alarms. She escalated. She kept a handwritten log documenting consumption that stretched back nearly a decade. After her arrest, investigators found paraphernalia, partially consumed samples, and the log at her workstation, a ledger of use written in the margins of a supposedly rigorous process. Defense attorneys asked how no one noticed. The answer is procedural. Supervisors rarely audited analyst behavior. Internal controls prioritized tracking evidence packets over monitoring the people handling them. The result was a blind spot large enough for a single chemist to turn a laboratory into a personal supply chain. The human cost of that blind spot was concentrated and measurable. The people affected were disproportionately poor, represented by overworked public defenders, and located in communities with limited resources to challenge state evidence. Many pleaded guilty because laboratory reports from a state facility felt decisive. The risk of contesting certified forensic results at trial often seemed too high. These guilty pleas removed cases from courtroom scrutiny and locked in convictions based on tainted analysis. The critical revelation, and the point that reframes the entire scandal, came not from the original forensic failures, but from what happened after those failures were discovered. When Assistant Attorneys General Ann Kazmarek and Chris Foster reviewed Farak's materials following her 2013 arrest, they saw the handwritten log and other records showing impairment, dating back to 2004. Rather than disclose that broader timeline to defense counsel, they represented Farak's misconduct as beginning in 2012. That choice concealed roughly 30,000 additional cases from immediate review. It was a calculated decision to limit the scope of damage publicly acknowledged in order to preserve convictions. A subsequent inquiry by the Massachusetts Supreme Judicial Court described the prosecutor's conduct as rising to egregious misconduct. Despite that finding, neither prosecutor faced criminal charges, and defendants who served time based on Farak's falsified results received no individualized compensation. The legal and institutional aftermath has been partial and uneven. In 2017, the state's highest court ordered the dismissal of about 8,000 drug convictions tied to Farak's work, one of the largest mass dismissals in U.S. history. Thousands more cases were placed under review, and Farak pleaded guilty to evidence tampering and theft, receiving an 18-month county jail sentence. The 2 assistant attorneys general were referred to the board that oversees attorney discipline, but they were not criminally prosecuted. Structural reforms were discussed: enhanced inventory protocols, random analyst testing, improved oversight. Yet the core question remains unanswered publicly. How many people pleaded guilty because a state-certified laboratory produced convincing but contaminated results and never had their cases revisited? How many served full sentences without ever being told the evidence against them had been falsified? Those numbers are unknown, and the institutional trust once accorded to a single analyst's signature remains compromised. Subscribe to Case Files TV, because the system that convicted these people is still certifying results today.